I peruse the list of orators for today, and the reason why I did it most intently than I did in the past for other pieces of proposed legislation is precisely because this piece of legislation deals with very fundamental issues, entre autres, Section 12 of the Constitution of Mauritius, which is about freedom of expression. It finds its inspiration in the European Convention on Human Rights, which is at Article 10 of the Convention. And when any legislation deals with one of the fundamental rights of our Constitution, I am of the humble view that it is important not to rush through the reading or presentation, but it is important to halt and to reflect on each and every of those clauses that potentially could breach those fundamental rights provided for in the Constitution. Yes, it is a very technical issue in law, and when I read this piece of legislation, I read it with the eyes of a lawyer. It is not necessarily about policy, it is, but most importantly, about fundamental rights. And when I look at the list of orators, I am happy that not only I, as a lawyer, but also Honorable Yutim, as a member of the bar, Honorable Boda, who has not practiced for such a long time, but I'll be happy to hear his views with regards to the legal implications of this bill. Honorable Kushal Lobin, a lawyer, who will also give us his views. But it is unfortunate that the only lawyer who will enlighten us with a legal analysis is one and the only person in government side who happens to be the Honorable Prime Minister. It is indeed unfortunate that we are not blessed by the interesting remarks that I'm sure Honorable Kolendavelu could have made, the interesting remarks that Honorable Obigadu surely could have contributed, or Honorable Ganu could certainly have made, or Honorable Kalichern. But then I hope that we will maybe have an amendment to that list, because such an interesting debate and such voices would add to the debate. Why is it that some of their names are not on there? Obviously, it is government who can decide who will speak or who will not speak, and it is for the orator to decide whether they refuse to speak or because maybe they don't believe in the bill. I leave that for government side to reflect upon. But it's an interesting remark that I have to make. Mr. Speaker, I have listened with a lot of intent to the orator that preceded me. Now, I cannot blame him for being very economical with the understanding, his personal understanding of this legislation. I cannot blame him, and he cannot be told that he is wrong in any way, and one cannot fault him for not understanding the intricacies of this law that is being proposed. He has limited himself in a very limited way to speak about the good deeds of the leader of his party, the Prime Minister, and unfortunately, he has gone only around that particular issue and not managed in any way whatsoever to comment on fundamental rights. He has tried at one moment when the honourable member, and I quote, he said, freedom of movement, freedom of expression, freedom ici, freedom là-bas. In fact, let me say, it has nothing to do with freedom ici or freedom là-bas. It is not with such légèreté that those who fought for our constitution came up with freedom ici and freedom là-bas. In fact, whenever the framers of our constitution brought and fought for section 12 of our constitution, it was certainly not for freedom ici and freedom là-bas. But then again, I mean, I cannot blame him for he is not well-versed in this particular domain. He is most probably versed in other issues, which I myself am not versed. Each other can contribute in their own way, and I respect that. But let me tell him that, and tell you, Mr. Speaker, that I've read with a lot of interest what President Mandela has basically said in an address dated the 14th of February 1994. In that particular address, Mr. Speaker, sir, I will quote what he said because I find it quite relevant to the debate of today. In that address on the 14th of February 1994, strangely enough it was on Valentine's Day, and he was speaking at the International Press Institute Congress, and he said the following: "A critical, independent, and investigative press is the lifeblood of any democracy." I say that again. A critical, independent, and investigative press is the lifeblood of any democracy. Two important words there: critical, and obviously independent. Maybe not for the government, but for us, it's important that they be independent. Critical is the word that President Mandela used. Investigative. But when we hear the previous orator, who has been there to defend government's position, he said the role of the press is to inform. He chose very carefully, sir, not to go as far as to say that it was their role to criticize. Why did the previous orator not choose the word criticize? Why did he refrain from using the word investigative? In fact, he did not even use the word independent whenever he referred to the press. That shows you the real intent of this government. That shows you the opinion this government have as regards to the role of the press. The press, according to the minister, and I take it that he speaks for government and not only for him, it represents the views of each and every member of government whenever he speaks. They are there to inform. Full stop. But when President Mandela said that in his address, that the critical and independent and investigative press is the lifeblood of democracy, was he wrong? And was Honorable Toussaint right as opposed to Mandela? Or why is it that Honorable Toussaint or some members of this government would praise Nelson Mandela when it suits them politically? But when it comes to at least learning what the fundamental human rights means, liberty of the press means, that they will try to pretend they do not hear, pretend they do not see, and pretend that they are Democrats. President Mandela went on to say, the press must be free from state interference. This is what they're doing today, Mr. Speaker, sir, interfering in the press. It must have the economic strength to stand up to the blandishments of government officials. Mustn't a free press have the strength to stand up to the blandishments of certain members of government, including ministers? President Mandela thought so. And he went on to say, I quote, it must have sufficient independence from vested interests. But then again, in Mauritius, they have chosen whom they want to attack. They have clearly, as demonstrated by the Honorable Leader of the Opposition and Honorable Utim in their address, explained what the Honorable Minister Toussaint believes is irrelevant. But the trauma the harassment, the onslaught of authorities, strangely enough, controlled by government, against Top FM. And he believes that to be not important. President Mandela, I have to lengthily refer to what he says because he goes on to explain, he goes on to state that it must have sufficient independence from vested interests to be bold, and it says to be bold and inquiring, not only informing, as the Honorable Minister said, without fear or favor. It must enjoy the protection of the consultation so that it can protect our rights and citizens. This goes a far cry to the limit that Honorable Toussaint has set for the role of the press and radio. Because for him, they are only there to inform. And he goes on, here, it is only a free press that can temper the appetite of any government to amass power at the expense of the citizen. I accuse this government. Through this legislation, they are clearly...
You don't have the right to do that.
To do what?
You are accusing the government through this legislation. They are clearly... This is imputing motives.
Upon whom?
Be careful.
The standing orders say imputing motives against a member is wrong, but not against government.
Be careful, you continue.
So I shall not say that government is trying to control, because, Mr. Speaker, you've asked me to be careful and I will respect your views. So I'll not say that they are trying to attempt to control the press. Fair enough. However, when one looks at Section 12 of our Constitution, and before I go to Section 12, let me just read from a judgment of the Federation of Civil Service and Other Unions and others versus the State of Mauritius, 2009, Supreme Court judgment, page 214. In that particular judgment, the Supreme Court said the following, I quote, "We may straightaway say that ad hominem legislation per se should not be struck down unless it is unconstitutional." What is an ad hominem legislation? And I think here it is important for Honorable Toussaint maybe to understand. Just like he tried to say that I should behave, maybe he should learn. And at the same time, I will learn to behave. I'll take that. What he should maybe understand is what is an ad hominem legislation. An ad hominem legislation, which I'm convinced it is a piece of legislation that is not addressed to the general sector, but specifically in order to viser one particular entity. And that one particular entity that I am convinced this legislation is aiming at is Top FM. And when one goes further, when the Supreme Court judges say that we may straightaway say that an ad hominem legislation per se should not be struck down unless it is unconstitutional, it takes me to another important element, which is our Constitution. Section 12. It says here, the heading is Protection of Freedom of Expression. It says further, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section to the extent that the law in question makes provision for the purpose of protecting the reputations, rights and freedoms of other persons and the private lives of persons concerned in legal proceedings, preventing the disclosure of information received in confidence, except so far as the provision, or as the case may be, the thing done under its authority is shown not to be reasonably justifiable in a democratic society. So the question here is that when you open the door under clause 18A in this bill, and that you say that an application can be made to the Honorable Judge in Chambers. And this is what the members of the public listening to us today must understand. What the Prime Minister says is in fact a beautiful attempt to be economical with the truth. What the Honorable Prime Minister has done is voluntarily and willfully not say everything that is of relevance in this bill. Because he is a barrister of experience. He knows what the Constitution says. The fact that he did not make reference to Section 12 puzzles me. The fact that he does not make reference to that particular section that is clearly relevant puzzles me. And each and every one of us, Mr. Speaker, sir, honourable members, we take our solemn oaths upon this Constitution in this House. We are therefore obliged, if we are to talk of responsibility, we are obliged to ensure that no section is in any way violated, not a single of it, unless it is reasonable in a democratic society. The Honourable Prime Minister has failed to explain how is it reasonable in a democratic society to place a journalist in a situation where an ex parte application can be heard by a judge on an affidavit ex parte from this regulator stating, I need to have this information. How reasonable is this in a democratic society? Is it, therefore, not important for the members of the public to understand what is an ex parte application? An ex parte application means, as opposed to inter partes, that the application can be made by the IBA to the judge in chambers alone, without the other party present, without the radio station present, behind the back of the radio station. An application is made, Mr. Speaker, sir, there, and he says, maybe with untruths in the affidavit, potentially, only showing one side of the story. Come to the judge, knock at his door. Judge, I need, in the interests of my regulatory powers, to obtain this information. Therefore, the source that is supposed to be confidential, the information that is supposed to be confidential, the content and the source needs to be disclosed. And now the judge potentially could disclose it simply sur les dires du représentant de l'autorité, IBA. And if the journalist, plus important encore, if the journalist refuses to comply, because for him this is one of the sacrosanct ideas, principles that he believes in, that of his profession, that confidentiality shall not in any way be violated, because it is connected to the freedom of expression, Article 10 of the European Convention or Article 12 of our Constitution. The judge can then have an application for contempt against the journalist from a radio station. And if you have contempt because you've failed to follow what a judge says, you end up going to jail. I have gone then another step to try to see what does not only our Constitution say, but what does the European Court of Human Rights say with regards to this particular instance. I said before, and I underline for posterity, that this is a law that is in blatant violation of Section 12 of our Constitution and Section 3. It does not in any way represent anything that is reasonable in a democratic society. Because the one who introduced the bill failed in his presentation because he did not explain to us how and why, in what manner would it be reasonable in a democratic society to come up with a law that asks us to go around Section 12 of our Constitution. But then again, Honorable Toussaint maybe is right. C'est freedom ici, freedom par là. Who cares? So when I look now at not only the European Court of the European Convention on Human Rights, but I look at the judgments from Europe. Are journalists obliged by judicial order to disclose their journalistic sources? The European Court of Human Rights has in numerous judgments, I can quote chapter and verse, numerous judgments, without any exception, numerous judgments stated the following. In the case, for instance, of Vosquil versus the Netherlands, judgment on the 22nd of February 2008, the European Court of Human Rights found the following, in particular, that the Dutch government's interest in knowing the identity of the applicant's source had not been sufficient to override the applicant's interest in concealing it. Held that there had been a violation of Article 10 of the Convention, precisely freedom of expression. It further held that there had also been a violation of Article 5, which is about the right to liberty and security of the Convention. I can go on and on about all the judgments. It went go on. Financial Times versus the United Kingdom, 15th of December 2009. Again, the European Court of Human Rights held that the wish of a state to try to find out the source of information of a journalist is a violation of Article 10 of the Convention. And it goes on, the court said, emphasizing in particular the chilling effect arising whenever journalists were seen to assist in the identification of anonymous sources. It found that the interest in eliminating damage through the future dissemination of confidential information and in obtaining damages for past breaches of confidence were, even if considered cumulatively, insufficient to outweigh the public interest in the protection of journalist sources. Public interest. This is what maybe our friends, I say clearly, our friends on the other side should understand. That the interest of protecting the journalist sources, it is a public interest. Are we not here to serve the public? We are here guided, Mr. Speaker, sir, by the judgments of the European Court of Human Rights. And let me also underline that our Supreme Court, our last Court of Appeal, have all, in certain cases, sought to be inspired by the findings of the European Court of Human Rights in many matters of fundamental rights and breaches thereof. Our jurisprudence is rife with references to findings of the European Court of Human Rights, references and similitude between articles of the European Convention of Human Rights and our Constitution. Why is it today, therefore, that us who are supposed to be, each one of us having sworn upon this Constitution to uphold the Constitution whenever we have taken office, why do we forget, therefore, the very intricacies and essence of that Constitution? Freedom is what I'm referring to. Freedom of expression. Yes, I understand that the Honorable Prime Minister feels that he has to modernize, he has to come up en diapason with the actual developments that have happened in the press. But then, whatever he has said today does not make any sense whatsoever. Let me also say, today, and I think that members of the public must listen to us, we are here speaking pour la postérité. Because what's going to happen? Every single word that I speak, as I said, I read it as a lawyer. Every single word that I speak resembles the beautiful speeches that once upon a time the Honorable Prime Minister used to make whenever he was in the opposition. The importance of the freedom of the press. It reminds me also of what the former Prime Minister Sani Ujagnan also tried to do with the newspaper periodicals bill. Again, tentative de museler la presse. But in those days, the people did not stand for it. In those days, there was international outcry. In those days, those were the good days. But today, what's going to happen? And this is what people have to understand. This is what's going to happen. I'll write the script. Every single issues that we are suggesting, we are telling the Prime Minister that this is against the Constitution. The Prime Minister does not listen to anything we have to say, neither does he believe that consultation is important, because had he believed that consultation was important, he would have consulted. In the midst of a crisis sanitaire, he chooses to come with this bill. In the midst of people falling down like flies, he chooses to come with this legislation. Is this a legislation that will save lives? No. Are we not therefore to be concerned with only legislation during this dire moments? Legislation that saves lives. The Prime Minister has shown us where his priority lies. It is a pity that the Prime Minister has refused to consult. It is a pity that the system of government we have allows any Prime Minister to sit, wait for us to finish our interventions, ignore whatever we have to say, and use parliamentary majority by basically voting the law. So what the people have to understand is that the poison in this democracy is the system of government. And I said it outside and I say it here. Too much power in the hand of one man. And I do not pinpoint this Prime Minister. I say every single Prime Minister have too much power in their hands. And look at le Conseil supérieur de l'audiovisuel in France. Look at Ofcom in England. Those two institutions, it is not the Prime Minister as one man who decides everything as to who is to be named upon those bodies. It is the Parliament that has a choice. In France, it is the Président de l'Assemblée nationale that chooses at least 3 or 4 members, not the Président de la République. In England, you have a committee of selection to choose. In England, those members are accountable to Parliament. In Mauritius, they are accountable not to Parliament, to the Prime Minister. So, let us stop comparing and let us compare what can be compared. And I agree with Honorable Toussaint. I agree. And unfortunately,
2 minutes to conclude.
I agree. And that's quite sufficient. And I thank you, sir. I think that what we need to do right now is accept the truth. The Prime Minister will ignore. The ministers will do exactly what the Prime Minister says. In other words, if he says jump, you will jump. If he says sit, you will sit. You will vote the law blindly. And then, even if it is unconstitutional, posterity will remember each and every single member of Parliament who voted and what their vote was. And the day that it is turned down at the Supreme Court as being a violation of Section 3 of 12, then it will be too late, because maybe we would have destroyed a radio station. We would have soiled the importance of freedom of expression. Too late. And all this because we are here only to pretend we are a democracy. This Parliament is not only for us to just oppose, but whatever we are proposing here, hear it well. Stop violating the Constitution. Set up a committee. Discuss about it. It's about fundamental rights. But I know that this is not the objective of government. The objective of government is one clear for one and all to see. So when I read this piece of legislation, I say it again, it is an ad hominem legislation that has clear unconstitutional undertones. This is my contribution, sir.